Today we will get ourselves acquainted with the doctrine of judicial review. As we know, friends, judiciary plays a very important role in determining public administration, especially in trying to define the scope and ambit of public administration, and also to determine what is public policy from time to time. Judiciary is empowered under the Constitution to be the custodian of the Constitution and the rights of citizens. And hence, when you talk about judicial review, it is the role of the judiciary as enshrined in the Constitution of India to look at the powers of the legislature and the executive and to meet the doctrine of checks and balances. So it is the duty of the judiciary as the custodian of the Constitution to set the limits of government and governance. And hence, whenever the legislature oversteps or the executive decides to usurp its authority and power, it is judicial review and through judicial review that the judiciary sets the limitation to the actions and directions of the other two branches of government, that is the executive and the legislature. This doctrine of judicial review, friends, in India is defined in the Constitution. However, the initial idea as propounded in the United States of America by John Marshall in the famous case of Marbury versus Madison could be said to be the first kind of an idea of the power of judicial review. Now, in the United States, friends, the then Chief Justice of the US Supreme Court, John Marshall, laid down and said that judicial review is one of the essential principles of democracy. It is the basis on which democratic values and democratic policies can be protected and the limits of government can actually be defined. And the constitution of most democracies empower the courts and the judiciary to conform to the principle of judicial review so as to protect the rights of citizens and to also limit the power of the government. So it is government of the law, as has been said by the US Supreme Court, and not government by men. And hence, the history of liberty is the history of limitation of government power and not to increase, enhance, or abuse it. And hence, you will notice that John Marshall, the Chief Justice of the American Supreme Court, had remarked that the duty of the judicial department is to say what the law is. And if two law conflicts with each other, it is the court that must decide the operation of each of these laws. So, friends, in India, the Constitution confers the power of judicial review on the Supreme Court and the High Court. And hence, these two courts are considered as the constitutional courts. Further, you will notice that the Supreme Court of India has been declared to have the power of judicial review entwined into the basic structure and feature of the Constitution of India. And hence, the power of judicial review cannot be limited by any legislative action. And hence, the doctrine of basic structure that was propounded in the Kesavananda Bharati case in the year 1973 actually stated the power of the court. It actually restructured the premise that the judiciary shall be the final word when it comes to the interpretation of law and for the application of constitutional principles. And hence, any constitutional amendment will be tested on the point of the principles that are important in the process of protecting liberty, fraternity, and equality of citizens. So, judicial review, friends, is the power of the judiciary to examine the constitutionality, as legal experts will tell you, of both legislative enactments and executive orders of both the central and the state government. Friends, you will notice that legislature can also make certain kinds of delegated rules or delegated legislations. As defined under Article 13 of the Constitution of India, law will include any rule, order, regulation, ordinance, notification, circulars, and bylaws. These are delegated laws which the executive often is entrusted by the parliament to bring in as the force of law. And hence, if on examination The judiciary finds that any of these laws, either substantive law or procedure law, primary law that is made by the parliament in the form of an act, or delegated law that is made in the form of rules, regulations, orders, notifications, or circulars, if they are found to be in violation of the constitution or the principles of the constitution, which in turn we say is under the doctrine of ultra vires, because the constitution is the basic test for the legitimacy of any law, then the Supreme Court or the High Court have the power to declare the illegality, or what we call as the constitutionality, rather the unconstitutionality or invalidity of such legislations. So the courts can determine the test of any law as being violative of the Constitution, as being violative of the principles of the legality of the structure of the Constitution, or can also declare such legislations or the provisions of such legislations, as the case may be, as null and void. So, interestingly, once the judiciary steps in to declare any part or the entire law as illegal, unconstitutional, or invalid, then such laws will not have any force of law, and they shall be not be made applicable in the territory of India or during the territory of any state. So, judicial review, friends, has many aspects to it. First, can the judiciary review any constitutional amendment in the very first place? Because an amendment to the constitution itself is a law making process, though it is a higher law making process. So, in India, do the courts have the right to determine the legality, the constitutionality, or the validity of a constitutional amendment? The answer is yes, they do have. So, this is one of the powers of judicial review. Second, can they review the legislation of the parliament and the state legislature? The answer is yes. And third, can they review the administrative actions of the union and the state and the authorities under the state? The answer to that is also an affirmative. Now, the Supreme Court of India has time and again used the power and the doctrine of judicial review under various very important and noteworthy cases, including the cases of Golaknath in the year 1967, the bank nationalization case in the year 1970, the Privy Purses abolition case of 1971, Kesavananda Bharati 1973, and Minerva Mills in 1980, and so on and so forth. Interestingly, very recently in 2015, the Supreme Court declared the 99th Constitutional Amendment, which brought in what is known as the NJAC, the National Judicial Appointments Commission, in 2014, as unconstitutional and null and void. That clearly displays the supremacy of the doctrine of judicial review in most democratic systems. Friends, why is the doctrine of judicial review so critical and important? It is important because it will ensure to establish the supremacy of the Constitution and not of any other political party. Two, the doctrine of judicial review maintains federal equilibrium between the center and the various state governments, as the case may be. And finally, and most importantly, judicial review protects fundamental rights of the citizens in numerous ways and cases, as has happened in the past as well. So in India, I think the Constitution is the supreme document, and the custodian of the Constitution under the doctrine of judicial review happens to be the courts. Rightly so, under the provisions of the Constitution as well. Our Constitution has very specific provisions for judicial review. And if one goes to the phrases in Article 32 of the Constitution of India, or Article 226 or 227, one would very clearly look at the doctrine of judicial review, saying that there cannot be any law that violates either the fundamental rights or the legal rights of citizens. And hence, the Constitution has clearly dedicated itself to empowering the judiciary, placing the judiciary in such a high pedestal, giving it the power to review any such legislative or executive actions or orders, so as to ensure that the rights that are guaranteed in the Constitution are protected at any cost, and none of these are contravened by any organ of the state or its entities. The court is the ultimate body of authority to decide that every branch of the government is a limited government, and any such action of the branches of government or governance does not transgress its limits so as to impinge the fundamental rights of the citizens. And hence, you will notice that the power of the Constitution in granting writ remedies, including the habeas corpus, mandamus, and certiorari, and prohibition, are all such writs which the courts exercise under the doctrine of judicial review. So, to deprive the authority of the Constitution, to say that the authorities of the Constitution must work within the confines of the Constitution, is probably what is attempted under the doctrine of judicial review. Now, interestingly, friends, the scope of judicial review in India, at many times, people have said, is not as wide as what is the scope under the American Constitution. But I think we must look at not the wordings of the way and process in which the Supreme Court and the High Court is empowered, but in which it has been exercised. And hence, that is what we say is the difference between constitution and constitutionalism, or the working of the Constitution. So, if you have seen the working of the Constitution and how the Supreme Court has exercised the scope of judicial review in this country, you will notice that the Supreme Court has time and again come to the rescue of citizens in protection of their fundamental and legal rights. They have tried to limit the power of the police state. They have tried to decide the welfare uh, agenda of certain governments. They have ensured that any such law that violates or attempts to violate the rights have been declared as void. They have also, to a larger extent, gone to the question of reasonableness, suitability of certain policy implications wherever it is utmost necessary to do so. Because, to be honest, the courts do not intervene in the policy matters unless and until the policy attempts to infringe fundamental rights or takes away or abridges or negates any such legal right of citizens. So they do maintain a perfect balance between what they should interfere and what they should not interfere. So one should very clearly conclude that whether judicial review in India establishes the supremacy of the judiciary and the constitution, the answer should be yes, it does so, because the provisions of any law can be struck down, and they could be struck down if the provisions of the law are in violative of the principles of the constitution or in violative of the principles of natural justice, which is in the American Constitution called the due process of law. And hence, the judiciary is the one that is the ultimate word on how laws have to be made and implemented in this country. And they would decide the course of any such sovereignty or supremacy of the law, as the case may be. The doctrine of judicial review becomes very, very critical and important when one looks at the way center state relationships have been protected and maintained and balanced by the courts. Now, center state relationships in India have undergone a lot of turmoil, unfortunately, thanks to the way in which the powers of what we call as the president's rule under Article 356 have been misused by, by governments in the past. So, in the most famous case of S.R. Bommai versus Union of India, it is the doctrine of judicial review that laid down how this power has to be exercised and in what manner, and to check the abuse or misuse of president's rule in the state governments. It is the Supreme Court that stepped in to limit the nature of governance. So I think there are many such occasions which can be brought into place to substantiate how judicial review has worked in India. Interestingly, one of those topics that would be far relevant for us to discuss here is the topic of the ninth schedule. Friends, the ninth schedule in the Constitution is a very interesting schedule. You will notice that the ninth schedule is a schedule which was added by the first Constitutional Amendment Act of 1951. It was not part of the original Constitution, so it was added. Now, in the ninth schedule, you will notice that one could bring certain legislations and keep it in the ninth schedule, thereby stating that the judicial review of these legislations can be taken off. So, any legislation that is brought under the ninth schedule will not be part of the judicial review, was what was done through the first constitutional amendment in 1951. So, Article 31B says that the acts and regulations included in the ninth schedule will not be challenged or invalidated on the grounds that they contravene fundamental rights. And hence, 31B literally looked at limiting the doctrine of judicial review or the power of the judicial review, which, in many contexts in United States has no such limits or no such power. As it were, you will notice that, friends, originally as it was started, the ninth schedule include those legislations that were in tune to the zamindari system, where we thought about abolition of the zamindari system. We brought in certain legislations on land sealing and land tenancy, and these were basically legislations in the land reform movement, which had a kind of a attempt to infringe a fundamental right, which is the right to property. Because under the abolition of the zamindari system, those people who were holding these lands but not tilling it, as zamindars, they were only collecting some kind of revenue or royalty from the tenants. They would actually go to the court and say that, look, their property rights have been violated, which is a fundamental right, and hence to that extent they should be compensated and these laws should be held to be invalid, was the automatic challenge that could have arisen in many of these instances, and which would then kind of disturb the state's agenda of bringing in equality on the distribution of land as a resource, because you do not want concentration of wealth in the hands of few. That is what Article 39B and C of the Constitution Directive Principle State Policy also say. So, to have equal distribution of these lands and to make the tiller the owner of the soil was an agenda that started in the first land reform movement in the country. And various legislations regarding the same, especially like the abolition of the Zamindari system, the land sealing law, land tenancy acts, were all enacted and they were immediately brought into the ninth schedule so that the challenges on a fundamental right and judicial review will not be done. Now, you will notice that while the ninth schedule originally had 13 legislations, in 2019, if one counted the number of legislations in ninth schedule, it had increased to around 282 legislations, which were supposed to be completely out of the domain of judicial review. However, you will notice that in 2007, in a very significant Supreme Court judgment, in a case called IR Coelho, Coelho, that is IR Coelho. In this case, the Supreme Court ruled that there cannot be any blanket immunity from judicial review of laws that are included in the ninth schedule. The court held that the judicial review is a basic feature of the Constitution and it could not be taken away by putting any law under the ninth schedule as it is. It said that the laws placed under the ninth schedule after, please note this date or this cutoff date becomes very relevant and important, April 24th, 1974. Friends, April 24th, 1974 is a very important day in the history of the Indian Constitution because it was the day when Kesavananda Bharati case laid down the basic structure theory. And judicial review is a basic structure, and from there on, there cannot be any act of the parliament, including a constitutional amendment, which can actually take away judicial review in any manner or any process. So, if any legislation has been added to the ninth schedule after 24th April 1973, such legislations will be subject to judicial review. But prior to that, anyway, they were times from 1951 to 1973 when the Supreme Court decided to limit its own power and excluded judicial review of legislations under the ninth schedule. So it is now open to the court to review any legislation, in the ninth schedule, especially those that have been brought into the schedule after 24th April 1973, if they would violate the fundamental rights of citizens, because the doctrine of basic structure becomes very core and important to how the doctrine of judicial review has been developed in the Constitution. Now, in the IR Coelho case, the Supreme Court says that a law that abrogates or abridges the rights of citizens guaranteed under Part 3 of the Constitution, such kind of law will violate the basic structure of the Constitution, and hence any such law that attempts to do the same shall be subject to judicial review, and the constitutional validity of such legislations, whether they are ordinary legislations or legislations in the ninth schedule, will be subject matter of the rights test. This is what it means, the rights test. The rights test means any form of an amendment is not relevant to the Constitution until and unless it affects or determines the rights of individuals. So that, I think, is a very interesting development of assertion of judicial review, or the doctrine of judicial review. And I think the Supreme Court judgment in 2007 very clearly says that the essence of the right test is the only basis for intervening in the law of judicial review. And the judges have the right to challenge any law if they violate the fundamental rights of citizens, or if they lead to any kind of infraction on the basis that they damage or destroy the basic feature or the basic structure of the Constitution in either Article 21, Article 14, or Article 19. As I told you, this is the golden triangle rule. So if at any point of time any of these three articles are going to be kind of touched by any kind of public administration or by public policy or public law, then they shall be subject to judicial review of the Constitution. So I think this very clearly goes on to say the very basic feature and aspect of judicial review, or the doctrine of judicial review under the Constitution of India. The important cases are definitely the Kesavananda Bharati case and the A.K. Gopalan case. We have already discussed that. Now let us move on to understanding public interest litigation and judicial review. Now, before we go forward to understanding this, it is important for us to understand that the judiciary has been a very active judiciary in this country, especially in the last 4 to 5 decades. And this has been by many of us, especially who have looked at what is public interest litigation and how judicial review through public interest litigation has been made possible in this country, will call this nothing but judicial activism. Of course, at this point of time, a lot of us may critique judicial activism as being judicial overreach or over activism, but I think that is a fallout of every other public opinion that one has on whatever happens in the public debate. However, judicial activism, friends, again, is something that comes from the United States. This is a doctrine that was introduced in the mid 70s by judges like Justice V.R. Krishna Iyer, Justice P.N. Bhagwati, Justice O. Chinnappa Reddy, and Justice D.A. Desai. They laid down the foundation of judicial activism in the country. Now, what is judicial activism, friends? It is nothing but a proactive judiciary. And the judiciary plays a very important role in the protection of the rights of the citizen and the promotion of justice in the society. And hence, what does the judiciary do? It plays a very assertive role. It's not a very passive role. It's not a spectator, but it's an active player to actually look at the functioning of the two organs of the government. And they do monitor whether the two organs of the government are discharging their functions as per the constitutional mandate. So this is nothing but, like many jurists would call it, it is judicial dynamism. And it is an kind of an antithesis to what we call as judicial restraint. Now, in many cases, judicial restraint means judicial self-control, which is also very important, because the judiciary also should not overstep into the domain of the legislature and the executive. And you will notice that in cases like the same-sex marriage case that was recently pronounced by the Supreme Court, you will find some element of judicial restraint in those matters as well. So, judicial restraint is important, However, the judiciary has been an active judiciary. Uh, it has kind of motivated its own institution, as I would want to say it, because the Supreme Court and the High Courts, it's an institution. The judges are only members of this institution. It has motivated the institution to go away from the normal routine practice, or what we call as the strict adherence to the judicial precedent and procedures, which actually delay justice. So you will notice that progressive judges with progressive mindsets have laid down new benchmarks. But more importantly, friends, they have laid down new societal policies, and they have kind of taken the common practices out, or common customs out, and they have really done what we would want to call it as social engineering. And hence, you will notice that at the cost of a slight intrusion into legislature and the executive matters, the judiciary has been protecting individual rights, especially the rights of the vulnerable sections of the community and society, including women, children, indigenous communities, people, and others. And hence, you will notice that where the legislature has not acted, the judiciary has stepped in. This is also called the theory of filling the vacuum at times. And hence, despite several oppositions and quite a few constraints that the judiciary did face at its very initial stages, the process of judicial activism has contributed to what we call as judicial lawmaking. So, we will take some examples of judicial lawmaking in the next slide, but it is very important that judicial activism has been a process of judiciary and judges trying to not only do the regular role of active interpretation of existing legislations, of not only looking at the traditional rule of dispute settlement or dispute resolution, but they have also looked at the utility of this legislation, and they had looked at social betterment of the lives of individuals. They have come to the rescue of people, especially when there are some harassments that have been committed. And you will notice that in the cases, the judges have gone beyond their personal ideology and opinion, and they have looked at public good and public welfare and determined the facets of what we call as public policy. So, a new kind of philosophy of the judiciary has laid down new principles. They have laid down new concepts. They have laid down new formulas. They have come up with the very innovative relief to citizens, thereby expanding the kind of a standing of why the people must knock at the doors of the judiciary and seek different aspects and ambit of justice. So I think judicial activism is been one of the talking points of reference and feature all over the world of the Indian democracy and the Indian constitution, and it's a feature that has always withstood the test of times. Now, the concept of public interest litigation, friends, was kind of antithesis to what we call as a private interest litigation. Now, a private interest litigation, a person is a victim or an aggrieved individual who goes to the court as a petitioner and seeks relief and remedy and justice from the court. So, you are a party who is having some standing before the court of law, and you will say that this is what is the relief that you personally want. In reverse contrast to this, the public interest litigation philosophy is a litigation by an individual or by an NGO or by a public spirited body who goes to the court not for relief for themselves but for those who are not able to access the court or access the justice. So they are not private interested litigants, they are public interested litigants. They do not get any remedy or relief. It is the general public who are supposed to benefit, or the concerned group of individuals on whose behalf that NGO comes to the court, who actually get relief from a public interest litigation. So, public interest litigation is different from class action litigation in a sense that class action means a group of affected victims, like, say, a trade union or workers who go to the court to seek some kind of remedy. They would be considered as a class, one class of individuals going to the court. So, it's a group or class action litigation as well. So, public interest litigation is more known as social action litigation. You are going for a social cause, not for a selfish cause. You are interested in social welfare and social benefit, and hence you are invoking the jurisdiction of the court. And this is where jurists have believed that the principal rule of locus standi. Locus standi means what is your standing before the court of law? Why are you coming to the court? You have to justify the same, right? What is your locus before us to appear before us or to file a case before us? You have to justify. But this rule of locus standi has been diluted by the judiciary, and they have allowed the permission of the public interest litigation process, and that has been done through for larger public interest and public good. And I think that has been the touchstone of Indian judicial activism, as the case may be. Interestingly, if you see, uh, how has this concept of a PIL or judicial activism uh, kind of being used by human rights and other kind of groups. Please note, some people have used this for establishing their civil rights, civil and political rights. Some people have gone in for social and economic rights. There are consumer groups that have gone to the court. Bonded labor groups have gone to the court. Environmental groups, those who are opposed to large dams or irrigation projects. Child rights groups have gone to the court. Groups that are fighting custodial violence, custodial death, prisoners' rights, they have used the PIL process. There are a lot of groups that are fighting for poverty or elevation of property that have used the PIL and judicial activism process. Indigenous people, women right groups. Of course, there are groups that belong to certain kinds of association, including the bar associations, or even the legal services authorities has sometimes used the judicial review and the public interest litigation groups. So many a times you will notice that even the media has used the process of public interest litigation and the groups regarding the same. So I think judicial review and judicial activism are closely connected with each other, but they could be different at times. For example, we say that judicial review was very much existing before judicial activism came into picture, and you will notice that while we say that in judicial review, the lawmaking policies are actually tested. In judicial activism, it is the exercise of these policies, to whom and how it should be exercised, is usually attempted to be covered. And hence, while judicial activism is out of the necessity of inactions from the legislature and the executive that has propelled judicial activism, I think judicial review was to limit the two other organs of the government, right? Uh, and judicial activism is a 20th century kind of a philosophy where judges are attempting to make very positive contribution to law. They're setting standards of how judiciary and judicial institutions have to be very positive and assertive in protecting and promoting certain core rights. And hence, you will notice that judicial activism has its own charm, and judicial review now has become a kind of a part of the judicial activism process. Uh, the reason why people would justify judicial activism, and please note, a lot of authors have done it, is because they feel that sometimes the governments do not have a clear majority, and hence are they have got into what we call as policy paralysis. Very often than not, the executive has failed to discharge its functions, and they continue to do that. They don't really inspire the confidence of the people, and hence the judiciary is the only institution where the citizens can run up to and seek for protection of their rights and also fix the responsibility of the government. Also, judicial activism is justified in the sense that there is a lot of kind of pressure on the kind of population that we have in the country. There is a lot of aspiration, that is a lot of conflict of growth and protection of religious and other customs. And the judiciary is the only way that can actually alleviate the suffering of the masses whenever such kinds of conflicts arise. For example, very recently, the Supreme Court has said that wherever there is some kind of a violence or riot that take place due to some kind of a band or a political protest, Then if any public property is damaged, then it should be recovered from the assets of the persons who had taken part in such kind of a violence, which I think is very important to bring in some kind of accountability even under your right to protest or your right to strike. Judicial activism is generally, I think, justified because the judges feel very enthusiastic to participate in the social reform process. They take upon themselves that kind of a role. They have liberal ideas, liberal approaches. They feel that they have the duty to render justice, which is social, economical, and political, and they have to protect the constitution, make it work. It should not be simply a letter of law in words, but also in spirit. So, whenever the legislature has failed to discharge its responsibility, both either center or state, I think judicial activism has been completely justified. And the weakness of the government has been the survival instinct of the judiciary to actually power those who are honest, to power those who are hardworking, and to power public interest and public issues. So I think when it has come to the aspects of decent life in India, it is the judiciary that defined the basic tenets of right to life. It talked about the right to environment, the right to health. It talked about how the system of administration of justice, whether it be the police or be it any other executive organ, should work. Uh, just look at how the judiciary, through the public interest or litigation process, has checked the misuse of emergency power in this country, has tried to look at ulterior motives of government and parties, especially in terms of defection and other things. I think the kind of media that we had and the media frenzy that we had, you will notice that to a larger extent, even on the media, I think the judiciary has been able to balance as against the rights to the responsibilities that the media should have. So the expansion of judicial review over administration uh, has, in some way, promoted open government. It has promoted transparency and accountability. To a larger extent, you will notice that wherever jurisdiction did not exist, it is the judiciary that decided the jurisdiction. It laid the standards of rules of governance and delegation. And finally, the judiciary was very much involved in laying down what we call as the principles of natural justice. I think there are several judgments where the tenets of administrative law or the principles of natural justice have been laid down by the judiciary from time to time, and I think that has in some way kind of modulated how the administration has to be sensitive in terms of ensuring that there is a fair hearing, there is no bias, and then orders are being passed without fear or favor. So I think to a larger extent, all the kind of fear that we had in India, some of them are fears of ideology, for example, because you may not be supporting the ruling party and you may be supporting the opposition party. Some fears of management or mismanagement from the administration. There were so many other fears that Indians unfortunately faced in their early part of their constitution. I think the judicial review was able to instill a sense of confidence in the masses and in the people. And I think that is how the country has been able to progress thanks to the strong Supreme Court and strong court delivering strong governance as well. Now, if you see how the Supreme Court has defined public interest litigation in Janta Dal versus S. Chowdhury, it said that a legal action initiated in a court of law for the enforcement of public interest or general interest, in which the public or any classes of community have pecuniary interest or some interest by which their legal rights or liabilities are affected, can be the process in which you can define what a public interest litigation is. So I think the Supreme Court has laid down a set of guidelines on what a public interest litigation and how and which public interest litigation will be entertained. And they have also decided to impose cost if there is a frivolous PIL that is being filed. Uh, However, you notice that the process of activism has meant that in the past, PILs have been filed through certain letters that were written to the court, and those letters were converted into public interest litigations as well. So there are several such issues that have been resolved and brought to the forefront thanks to the judicial dynamic approach that we have in the country. And I think while the critics may call for judicial restraint, there is enough justification of encouraging judicial activism to the highest level. Now, judicial lawmaking, friends, has been also a process in which you will notice that the courts have taken a serious note of, and you will notice that in judicial lawmaking, the parliament itself, while it failed to make a law, the judiciary had to step in the interim phase and make what we call as judge-made law. Now, the examples of judge-made law probably are best explained through the case of Vishaka versus State of Rajasthan. This is where the Supreme Court, till 2013, from the time the Vishaka case was decided in 1996, had laid down a law on prevention of sexual harassment of women at workplace. Now, you will notice that judicial lawmaking in India is a reality, and the judiciary is able to enforce this law thanks to the power that it has in terms of the law of precedent and, of course, the enforcement through the law of contempt. So, the Vishaka versus State of Rajasthan is the best example of what we call as judicial lawmaking in this country. However, you will notice that several other cases, including the child labor law of 1986 that was brought about, was something that the judiciary had to interpret and apply even before the rules were brought in. And it is the judicial law as well as the legislative law that ensure that child labor in India is eradicated, at least wherever it could be possible. The Kesavananda Bharati case laid down the law on basic structure, that is also a lawmaking power. As I told you, SR Bommai case is also very, very relevant because it talked about Article 356 and how precedence rules can be imposed, especially not disturbing the center-state relationship. That is also a huge lawmaking factor by the court, protecting the federal structure as laid down in the Constitution of India. The DK Basu case is also another case where guidelines and statutory safeguard for arresting a person has been laid down. That has become a basic law of the land. And the DK Basu case is important because, to a larger extent, it set the limits of police power. For example, some of these guidelines very clearly say that a lady cannot be arrested after 6 p.m. And kept in police custody unless there is a fear that the lady is going to commit a very serious offense. So she should be only arrested in the presence of a ready police officer and only from 6 a.m. to 6 p.m. Unless there is a fear that she could be involved in commission of an offense or is involved in a serious or grave act of action against the nation or the security of the state. The second judge's case and the third judge's case is also one interesting case because it laid down the law on collegium system where the judges would recommend who shall be the members of the Supreme Court and High Court and who will decide the transfer of judges. So the collegium system now is where judicial lawmaking in terms of appointment of judges is actually being determined. And that also is one interesting example of how the judiciary has been making law in the process of what we call as judicial activism. Now, if you look at the Murli Dev case, Murli Devra, this is a case of smoking in public places. Now it has become a law under the Prohibition of Smoking in Public Places rules of 2008 under the Cigarette and Other Tobacco Products Act of 2003. But it was the Supreme Court that actually looked at the right to health of non-smokers, or as we call as passive smokers, in this 2001 judgment. So, to conclude, friends, I think while we should say that judicial activism or judicial role through public interest litigation is not something that can solve all the problems in the society or all the problems of individuals. It is nevertheless some era of hope that citizens have, especially when they feel very helpless when the executive and the legislature do not respond to their plea. And to a larger extent, I think there has been protection of basic human rights of the weaker and disadvantaged sections of the community. I think through the PIL, the courts have been encouraging genuine, public spirited individuals. They have been giving them credentials of bringing social transformation in the society. I think prima facie the court, when it is satisfied that the contents of the petition are bona fide, I think the courts have intervened in the larger public interest. Sometimes they've intervened in urgent hearings. And looking at the gravity of the situation, the courts have actually abated public harm and public injury. And that, I think, is something that no one can dispute. And the courts have never gained anything out of it. And the primary motive is to just ensure that the principles of the constitution are protected. And they have adopted methods in curbing frivolous petitions. And they have checked the misuse of the judicial activism process as well. So finally, you will notice that while we say that there is right to privacy today, that right to privacy comes from the Puttaswamy judgment, and before that it was in the Correction case. Again, you will notice a new unenumerated right, a right that is not in the Constitution, has been spelt out by the Supreme Court in the KS Puttaswamy case. The right to privacy, interestingly, in the information age, as we call the digital age or internet age, was said to be a fundamental right by the Supreme Court. So this is how, through judicial activism, the court gives you a new fundamental right, like several other fundamental rights that have been granted to us from time to time. I think this should kind of give you an idea of judicial review and judicial activism and public interest litigation, and it should help you understand how judge or judicial lawmaking happens in the country, and how the judiciary has been able to contribute to public policy and also determine the scope of public administration.